I'll be cheering on Rutgers for next week.
Uh-oh.
Wow. Now wait till he gets out of camera view and then take him down in the hall. No. Take care. Wow. Really nice guy till that. Court does call the case. People State of Michigan versus Chloe Whitsett.
Edward Dirks on behalf of Chloe Whitsett.
Chloe Whitsett.
Okay.
Your Honor, today's time and date set for probable cause conference. We adjourned last time for her to obtain counsel. My update from last time is she does report to me that she did obtain counsel and would plan to have them here at the next hearing. On her behalf, I'd ask for an adjournment.
Counsel approach. Counsel approach. Ma'am, have you retained other counsel? I think you indicated that the last time.
Yes, I have. But it was very last minute when I paid them. And again, the counsel that I have retained, I really did not want to say the name of the Perkins group, but the attorney is either a representative directly of the Todd Russell Perkins group or a referral from him, because like I said, this is a favor. I was telling him that it's a favor to me. He's not even charging me what he charges normal people. I didn't even give him what.
Okay, I don't need to know all of that.
Yeah, well, I'm just saying
But yes, what I'm going to do is I'll adjourn this out 2 weeks to the 25th at 9 a.m. or your time that's set by the court.
That's fine. That's enough time.
And ma'am, the last time that you were here, we had a problem, and I'm just going to call it what is your attitude or somewhat your demeanor. And that, I thought we were straight when you left, but you're sending what at least people are considering harassing emails to the Department of Community Corrections.
Mm-hmm. What I'm saying community corrections outside of what's required.
That's what I'm asking. I'm driving.
I think when she's
What can it be modified is what I'm saying. Because
right now they're not going to modify it. You can ask to modify it the next court date.
Okay, yes, however they will.
Ma'am, I don't want, there is no reason for you to be emailing them.
Well, they were,
No,
sir, no communications.
They call you, you talk to them, that's it. But this stuff, I don't know why you're trying to do this. Because this is just, you almost got yourself locked up the last time that you were here. By me.
I can't say anything.
And finally, you got yourself calmed down. I passed it because I didn't know what was bothering you. I passed it. When you left the podium and you left my courtroom, I thought we were all on the same page about how people should be treated and how we were going to do everything. And then I get here now and I get this. So I'm just going to tell you, I don't want anything improper. If you've got an attorney and you've got to, for whatever reason, express something or communicate, tell your attorney and have them communicate with community corrections. I'm just going to give you this admonition. If I get something like this again, I'm likely going to revoke your bond. Did you hear me, ma'am?
Yes, sir.
All right. I just don't want to see it. There's no reason for it. See you on the 25th. Bond will continue.
Thank you, Your Honor.
Public Defender Jay Bellinger on behalf of Mr. Belcher, who stands to my right. Mr. Belcher, will you please state your name for the record?
I am Thomas Ryan Belcher.
Thank you.
I would also like to fire my public defender, please.
Okay.
At this time,
Why is that?
I don't feel he's giving me proper reputation.
Okay. In what way?
He's not giving me proper reputation. he wants to adjourn it, and I've asked him not to. He won't come to see me and talk about my case at all. So
So nobody's talked to you about your case?
a couple of times,
Oh,
but
yeah, okay.
I just don't feel he's fit for to represent me at this time.
Really?
Yes, sir.
Oh, that's the only objection you have?
At this moment, yes.
And it's just him? Well, it's an office that is representing you.
I understand that. I've asked him not to have it adjourned, and he's trying to have it adjourned with.
Okay, so you want it set for prelim?
I would like that. Yes, sir.
Okay, is all the discovery complete, counsel?
No, Your Honor.
So you want to go to prelim without all the discovery being in and not knowing everything?
I
that
also
what you're
would like a
telling
new
me?
public defender too. This
What?
time.
Well, you'll have to deal with their office regarding that, but he's here. He's qualified, he's representing you. He's trying to actually protect your interests by not setting the exam where he doesn't have all of the information to be able to adequately discuss it. But I presume with your law degree, you decide you want to do it some other way.
I actually do not have one.
Yeah, that's what I thought. Kind of knew that. That's why you should probably let him handle it. Did you want to see all your discovery or you just want to go to exam?
I would like to see it.
What?
I would like to see the discovery.
Okay, so the only way that's going to happen is by following exactly what counsel wants to have happen to adjourn it so he can get it all, sit down and talk with you. Does that make sense?
It does, yes.
Yeah, it sounds probably the same thing he said to you. You'll just take it from me, but you won't take it from him. That makes no sense. Instead of talking, you ought to start listening. Your motion to fire counsel is denied. Counsel, you want an adjournment?
Your Honor, we would just be asking for 2 weeks. There is an investigation finishing up in our division.
April 25th, 2024, 9 a.m. so that you can get all of the information and talk to your accountant until you're fine. Thank you. Bond continued.
Was there a finding on competency?
Oh, actually, I believe
There
there
is.
was. Thank you
Bring him
for
back.
bringing that up.
I just want to make sure before we.
No,
I don't know that, did we do the finding? I thought we had.
If you did,
No, we did not.
No, it's okay. It's not your fault.
The report indicates that he's competent.
And Your Honor, we have reviewed that. I
But
do
they
have
didn't hear what happened today. But anyways, never mind. Go ahead.
we've been able to review that. I have given Mr. Belcher a copy of that as well. We would stipulate to the findings.
People also stipulate to the finding. Defendant is found competent to stand trial in this matter. Court specifically would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Counsel, please file an order, and I'll set the probable cause for the time that I set on the 25th. Bond continued. Thank you.
Your Honor. And Assistant Public Defender Jay Bonjo on behalf of Mr. Cyrus, who stands to my right. Mr. Cyrus, can you please state your name for the record?
Yusuf Cyrus. You want to fire him too? No. Okay, all right. I just thought I started out trying to figure out what's going on. Go ahead.
We're good, right?
You're good.
Your Honor,
If he had said yes, I would have said, wow. Anyway, go ahead.
The courtroom session opens with what appears to be a routine procedural hearing, but very quickly it becomes clear that the atmosphere is anything but ordinary, as tension, frustration, and human emotion seep into every exchange between the judge, defendants, and attorneys. The first matter involves Chloe White, who appears before the court for a status conference after previously requesting time to obtain legal counsel. Although she confirms that she has retained an attorney, her explanation becomes rambling and defensive, emphasizing favors, reduced fees, and personal connections rather than clarity. A judge, maintaining control, cuts through the unnecessary details and grants a short adjournment, but not without issuing a firm warning. He addresses her prior courtroom behavior and what he characterizes as inappropriate, borderline harassing communications sent to community corrections. His tone sharpens as he reminds her how close she came to having her bond revoked during her last appearance, making it clear that the court's patience has limits. He draws a strict boundary: no unauthorized emails, no side communication, and no attitude. Any future misconduct, he warns, could result in immediate consequences, including jail. This moment sets the emotional tone of the session authority asserting itself against confusion, defiance, and lack of discipline. The court then moves to the case of Thomas Ryan Belter, who immediately requests to fire his public defender, claiming inadequate representation. His complaint, however, is vague and largely rooted in frustration that his attorney wants an adjournment rather than rushing into a preliminary examination. The judge methodically dismantles Belter's argument, explaining almost like a stern teacher that proceeding without full discovery would be reckless and harmful to his own defense. When Belter admits he has no legal training, the judge uses that admission to underscore why professional legal guidance matters, emphasizing that listening is sometimes more important than talking. The motion to fire counsel is denied, and an adjournment is granted to allow the defense to complete its investigation and review discovery. This exchange highlights a recurring theme in the courtroom: defendants believing they know better. Clashing with the legal reality that procedure exists for a reason, the proceedings continue with a competency issue, which is calmly but decisively resolved. After reviewing the evaluation, both sides stipulate that Belter is competent to stand trial. The judge formally states that the defendant understands the nature of the proceedings and can rationally assist in his defense, reinforcing the court's commitment to due process even amid frustration and conflict. Bond remains in place and the case moves forward, showing that despite sharp words and tense moments, the system continues step by step. Unmoved by emotion alone, throughout the entire session, the human element is unmistakable. There is impatience from the bench, confusion and defensiveness from defendants, and measured professionalism from attorneys attempting to navigate chaotic interactions. The judge repeatedly emphasizes respect, structure, and consequences, making it clear that while the court is a place for justice and fairness, it is not a place for games, grandstanding, or emotional outbursts. Each ruling, warning, and explanation serves as a reminder that the courtroom operates on rules, not personal narratives or perceived slights. By the end of the session, viewers are left with a powerful impression of how quickly casual defiance or misunderstanding can escalate, and how firmly the court will respond when its authority or procedures are challenged. This is not just a legal proceeding, is a raw snapshot of people colliding with the justice system, learning in real time that respect, patience, and listening are not optional, but essential. If you found this courtroom breakdown intense, eye-opening, or relatable, make sure to like the video, subscribe to the channel, and turn on notifications so you never miss another real courtroom moment. Drop your thoughts in the comments. Do you think the judge was fair or too strict? Your opinion matters.